Hello everyone and welcome to the video. I don't know how long this video is going to take because there's a lot going on, and I thought that I would try and explain what it is, the process that I'm going to use, why I'm going to use those tactics, and how long it will take in the legal process, and why I came up with these ideas really. So basically, round about the beginning of 2025, I noticed that the police were becoming quite aggressive and arrogant in their political standing, and they were becoming quite partial. They're supposed to be policing with impartiality, and that's what brings about the concept of consent to policing by consent. And so in the beginning of the year, I noticed that they were becoming really arrogant in their power again. So I took note of it so that I could bring a claim, and the discrimination element, which I recognised, that's only got a 6-month time limit on it, which is way past. I'm still dealing with the initial paperwork right now and trying to get the claim issued, so we're way past the 6-month time limit. I still think that I'll get the claim through, but I'm not quite sure how it's going to work out. And these are going to be civil claims against the police, and I also need to bring about a judicial review. Now, the reason why I haven't even considered bringing a judicial review is we did learn about it in our law degree, but it's very complex. Well, it's not very complex, but it's very much time limited. You've got 3 months to do it, and if you don't do it in those 3 months, then they do not allow it to go through. So I thought to myself, well, that's extremely limited. Why bother doing it? So I never really followed the whole process that clearly when I was doing law. It was only in 2025, around about June or July, I think it was, and a judicial review had been brought against the Northumbria police by a woman called Lindsay Smith. And Lindsay Smith is a lesbian. She objected to the police participating in LGBT Pride Parade because it had included LGB, which was lesbian, gays and bisexuals, then started to include transsexuals or transgenders or whatever they're called. And she objects to that. She doesn't like the ideology. She thinks it's a harmful ideology and it represents LGB poorly. And so she said that the police should not be participating in the LGBT Pride Parade because it's partiality. And she won. And all the police had to stop participating in any pride at that point, and that was this year. And I thought that was such an incredible case, and I realised that I could bring it into my own civil claims. And my civil claims, because of the contemporaneous evidence that I've got, I can expand on that. So I'm able to prove that DEI training harmed me. It harmed me in multiple ways. And this is with the police, and with also the NHS. So it was a public sector acting partially. And I'm also able to prove that non-crime hate incidences harmed me. I wasn't arrested, but we are all threatened with them. So I'm able to prove that prevented me from reporting a crime. Two crimes. And I'm able to use the refusal or withholding the suspect's description by the police, which I argue is further partiality because they're doing it on the basis of race. I'm also bringing negligence claims against the police. I've talked about that before. They're covered by something called Hill immunity, and that was from the 1980s. They still have that, but partially now, after the Robertson case, where an old lady, she was knocked over by a police chasing a burglar or a shoplifter or something like that. She was knocked over and had to have a hip replacement. And because that was a positive act by the police, so the positive act is them fulfilling their duty to prevent crimes or stop a crime, that's considered a positive act. And because it was a positive act which brought about that negligence, she actually won in court against that. And so positive acts are very important. What's important about the Hill immunity is that it was brought about for the police to protect the police from defensive policing. And I am arguing that DEI within the police is actually defensive policing. It's defensive because they're using it and abusing it so as to avoid claims for racial discrimination or LGBT discrimination. But what's happening right now is that LGBT or LGB are going after the police because they are being partial, and now disabled people and women victims of their enablement are going after them as well, which is me. So they are thoroughly failing, at least they're not collapsing. So I'm bringing a claim, also a judicial review against the College of Policing, and this is it's tactical and strategic. It's going to be brought before any civil claims will come through. So civil claims are taking about 80 weeks to be heard in the UK. So that's almost 2 years, right? Or 2.5 years, I think. I don't know, 1.5 years, let's say. So that's going to be round about 2027, 2028 when I get heard. So in the meantime, I might as well bring about some more precedents through the courts, and that's going to be through judicial reviews. And because you've only got 3 months to bring that claim, then obviously those cases go through a lot quicker. So my cases will be heard round about February to April, I think. And these are against the Home Office, the NPCC, which is the National Police Crime Commission, I think, or Chief Counsel, National Police Chief Counsel, and the Home Office and the College of Policing, so COP. They'll be heard around about February to June, and I'm hoping that they will set precedent in a positive way for me for my civil claims, which I've got coming up. Oh, I've also got LAA and CICA. So the LAA is the Legal Aid Authority and the Criminal Injuries Compensation Association. I'll talk about the police element first and Home Office. So, the College of Policing, they've got the non-crime hate incidences, which they do training on, and I've been bringing a claim against them, and they wrote to me. I wrote them a PAP, which is a pre-action protocol, and I let them know that I was bringing a judicial review against them on 3 elements, that is the non-crime hate incidents, the DEI training, and the withholding of the suspects' descriptions. And I've stated that the reason why I'm bringing a judicial review against them is that they prevent victims of crimes committed by groups who are especially protected. It prevents those victims from coming forward to the police, which makes the police basically useless to us. And they responded to my PAP, and they said that they'd received it, they understood that I was bringing a judicial review against them. I had their legal manager in the end emailing me. She admitted that they had been considering the non-crime hate incidences since February. I can't remember the language that she used specifically, but it is bad for them because it shows negligence since February 2025. Fit for purpose. We've been questioning whether it's fit for purpose, which implies that they recognised since February that it's not fit for purpose, and they're questioning that. And then she said that the review goes to the heart of what my complaint is about, which is a prevention of victims of crime reporting their crimes to the police. And she said, where do you stand now that you know that there's a review? And I said, well, you've only answered one element of it, and it's still continuing. You've not abandoned non-crime hate incidences. You've continued with them, despite also stating to me in your emails that you do not know whether they're fit for purpose, which just goes and cements my negligence claim against them. So we got that. And I also said, there's 3 elements to my claim against you, not just one, not just about non-crime hate incidences. There's 3 elements. So I'll continue to pursue the legal claim against you. I think the non-crime hate incidences reviews, that kind of puts that element of my claim on mute. So I'm going to struggle to bring that claim now because it basically strikes it out. It's quite clever how they've manoeuvred on this. I can still steer around it because I can say that it's public interest because thousands of people have been arrested for non-crime hate incidences and put on record. The thing is, I brought against them not only speech, a breach of freedom of expression, which is what Miller did in 2020, but I'm also arguing Article 7, which is no punishment without law. And I don't know if you know this, but the non-crime hate incidences, they aren't written up in any primary law. They're only written up in secondary law. So there is no law, and it's not even about them, it's about the College of Policing. So there's no law in the UK which allows and permits non-crime hate incidences. What I'm also arguing is that they've done this manipulatively and specifically to circumvent the judiciary. And they've done that because the judiciary holds a high standard for what is hate speech and stirring up racial hatred, and the non-crime hate incidences have a very low standard. So that's why they've done it, to circumvent the judiciary. And I'm saying that this is punishment without crime because it affects the people who get the non-crime hate report. They go on record, they've got all of their papers the police hold, and it can affect their employment, their employability in the future, which means a loss of amenity. And I'm saying that that kind of threat to a victim of crime committed by a protected group member is so alarming and so concerning that the victims would rather not report it. And that's going to be quite a difficult situation for them to get out of. Not only that, but my police reports on the file, they state it outright. So do my medical records. So does my CICA claim. So I've got such compelling evidence that these are really harmful behaviours and actions by the police, which is trained by College of Policing, that they will lose, or they will partially lose anyway. I don't think it's going to outright quash anything. I don't think it's going to do that. But I think that they'll have to go through reviews and annual reviews. But while I'm talking about how the College of Policing are using non-crime hate incidences to circumvent the judiciary and the law, well, that's what the LAA, Legal Aid Authority, and the CICA are doing. So when you go to a no-win, no-fee lawyer, you've got to litigate to them your claim, and then they will decide if it's going to be a winning case. And a winning case to no-win, no-fee lawyers is not gaining justice, it's gaining profits, right? So they will listen to your case. They will make a decision. Are we going to profit from it? If we are, then we'll take it on. But if we're not going to profit from it, then we won't bother. And so you litigate to a private company who judges you, basically. And then it could be the case that claim never goes to court because no one will represent it unless you do it yourself. Or it might be too complex as well. If it's a complex case, then they may just say, well, it's too hectic, it's too much time, we'd rather make the quick profit, which is basically what our legal system has turned into. So this is happening with the public sector, which is the Legal Aid Authority. So what you have to do with the Legal Aid Authority, and this has been receiving a lot of criticism in judgments since 2014. So this is probably why I didn't get told or notified about the Legal Aid Authority, and I didn't get legal aid for my rape case, and I had to self-represent. So what you have to do with the Legal Aid Authority and the CICA and all of that is you have to present and litigate your claim to them, and they will decide if they're going to provide you with the financial help to present your claim with representation. But if they decide it's not a winning case, then they won't provide you with the money to do that. And it's being criticised by the judiciary because they're saying, well, the executive is overriding the principles of the judiciary. The judiciary is meant to do with the judgments, not the executive. So there's already this sort of rift growing between the executive and the judiciary. And you've got that happening with the Legal Aid Authority. And bearing in mind that started happening in 2014, they really should have put an overview and reviews through and reports and all sorts of things to prevent that from happening, because it's discrimination. But they haven't done anything, and they've just ignored the judgments, and that's kind of what the police are doing. The police are in a bit of a worse situation, because if they ignore the judiciary, then they could face reactive judiciary in their, in their cases, in their prosecutions. They've got to tread a lot more carefully, perhaps. I don't know. But what I'm noticing as an observer of the legal system is that the executive is constantly either overriding or circumventing through manipulation the judiciary. And so there's a definite fragmentation between the two elements, which is interesting, and I'm going to use that to my advantage, and I'm going to do a lot of sucking up to the judiciary, because I'm going to be saying, well, I'm going to be pointing the finger out and saying, well, you're the judiciary, I have a lot more respect for you than I do for the executive, which is true. And the executive is making these judgments which they have no right to make. It's absurd and irrational. So that's that bit. So that's the College of Policing, that's the LLA and the CICA. And then I'm also going up against the Home Office with a judicial review. And that judicial review is about the anti-migrant posts on social media will be surveilled and monitored by an intelligence agency which is being set up, the NIII. And I've sent the PAP, the pre-action protocol, to the NPCC. And they've said, no, it's not us you need to deal with, it's the Home Office. So the Home Office have taken it on now, and they've agreed that it's them who I have to bring the claim against. And they're saying, well, it is in motion and it is intended to surveil. They have admitted that, and they've said, but we don't want to cause any harm to speech. Well, I'm bringing the same argument with the same evidence which I'm bringing against the College of Policing. So I'm arguing that it does prevent people from reporting crimes, because what if the crime is committed by a migrant or an illegal migrant? Will the people feel safe when the Home Office has got a special team, created a special intelligence team just to monitor, to safeguard only migrants? And they've also said it's to stop protests, which I'm the things that they reveal to you when you're a litigant in person is incredible. It's incredible. They absolutely admit illegality, which is wonderful to me, because I'm going to be bringing these things to the courts. But they actually say this stuff in their written pieces. It's shocking. Oh my goodness, I can't believe how they've admitted that they are doing this to prevent protests. Well, the thing is, they can't do that because protests are absolutely legal. So I've got a lot of good stuff going on, and I'm really excited about it. I don't know what else to tell you. I've got civil claims against some charities, which they could be very, They're valued at about 85,000, but then on top of that, my legal costs, which I would charge at £19 per hour, which would add another £30,000. So I could charge, at the end of the day, about £100,000 on each charity. There's 4 charities. I'm not going to do that because I think they're important charities, and I just want I want them to know that they should not be going down the partiality route of, they shouldn't become political. They should just do their job, basically. So I could just do a fast track claim without expenses, as long as I make sure that I'm not charged for their expenses, and that would be about £10,000. And I think I think I'll do that, but I'll keep these on record, on my own records, so that if they do it again, I can bring a claim again. Then there's police. There's 3 police forces who have kind of done some similar things. Now, one of them I have solid evidence against. The other 2, I'm not so sure how I'll do. I'm actually bringing claims against them separately, and I could consolidate all of them together, but that would mean that I'd have 6 defendants, and I'd be dealing with 6 defendants in a civil claim, and I'm not sure that I have that stamina about me. So I'll probably bring them separately, and the thing is, if I do bring them separately, 2 of them are a little bit iffy, one of them isn't. The ones which are a little bit iffy, they will probably go to the appeals court, and that's a good thing because my evidence will stand very firmly, but my claim against the police force may flop, really. So we'll have to see, and that's one of the issues that I've got to sort of consider. Do I want them to take it to appeal? There's another police force which I'll definitely win against, and they too. I think all the police forces will appeal. I think all of them will appeal. I'll definitely win, but yeah, I'm 2 of them are a little bit dodgy. I might not win, so I'm wondering whether to drop them 2 and bring it against the 1. But if I bring it against the 1, then they could argue, well, you didn't bring it against the other 2. You see, so I've got to be quite clever about how. I've got to be mindful about their arguments and assertions against me and how I'm going to play this. There's 2 other police forces as well, which I'm bringing claims against, and I'm very confident that I'll win them, especially since I'm bringing the judicial reviews prior, which will be this early next year, and then the other claims will be much later on. So I will have brought about some good case law by that time to help solidify my claims. So I'm not really fussed about that. I'm also charging like about £30,000 for my legal costs as a litigant in person. So that will tie me over, and it could even help pay for a barrister for the civil claims, you see. So it's all useful. And then what else? I think that's it, really. I just thought that I would update you on what it is that I'm doing. That I do have a strategy about it. The whole point is to bring and apparently this is what NGOs do. They We don't get NGO help in the UK unless you're a migrant, really. But they're the only ones who get the illegal migrants. They're the ones who get really NGO lawyers. We don't get them. But it's a tactic that they use. They take the public sector through the legal system with a judicial review based upon their irrationality, illegality, or their procedural anything wrong with their procedures. I'm having to do that. Oh yeah, because with my CICA claim and the LAA, that's important because I am way out of time on that. I'm years out of time on that. And then in 2025, it was in April, there was this case about trafficked women who were sold basically for sex slaves in the UK, and the CICA would not offer them any legal aid for representation because they were out of time, out of date with their legal claims. And the judge ruled that that would be an unfair trial, which goes against their their right to a fair trial. And they said that they needed to have legal aid, and that meant that that case law, that judgment meant that I can now bring my claim, bring a judicial review based upon that case law that they brought about my own claim, about my own case, where I was left to self-represent my own rape case like they were going to be. Because the point is, you either don't get representation, you don't get legal aid, therefore you don't get representation. So then a lot of people say, well, I just won't bother going for compensation then, and so they don't even bother, and I think that that's unfair. So that's kind of where we're at. I'm very confident. I've got amazing evidence. It's from medical evidence, police files and reports, and emails with the detective on my case, and then I've also got a lot of their own slip-ups that they've done in emails, admittances, which suggest that they are authoritarian, totalitarian creatures. So I've got a lot of evidence, got piles of evidence. I've got about 500 pages worth of evidence, very strong evidence. The thing is, if you use too much, then they've got more holes to pick at, so I've got to pick out the very best pieces, which I've got. I think that's kind of it. I'll let you know a bit more about what's going on. I suppose near the end of the year I'll know a bit more. But yeah, all I've got so far is that I'm dealing with the Home Office and the College of Policing. My civil claims have gone through. We'll have to see how they go. And I'm preparing with the use of judicial reviews to strengthen my claims for the future. And it's all very tactical, and there's a lot of intention behind what I'm doing, and there's a lot of reasoning as to why I'm doing that. I don't really follow alternative media, so I don't really spend much time on social media. So I might not really upload all that much. I don't know how other people are feeling about alternative media, but I just think that they avoid these sorts of things, like going through the claims and things like that. It's a bit more passive, I guess. I don't know, but I just don't follow it because it's very politically driven, and I find that politics is very emotional, whereas law is very logical and rational. There's a lot of reasoning behind it, which is way more balanced. Might not like the judgments and the rulings, but you've got to remember that the rulings are based upon the evidence brought to them on that particular case and claim. It's not necessarily about what's going on in the world beyond. It's about that claim. So yes, they seem a bit odd sometimes and out of sync, but they will get there. They definitely will. They are already getting there. So they're a lot slower in leaning towards things, and that's just because the claims don't come through. I think that's because we've got these representatives who kind of gatekeep, if you think about it, because if you think about no win, no fee, they only pick the cases which are going to be easy. So they're going to be picking ideological, especially if everything's turned ideological, then they're going to choose the easy ideological cases. And the people like myself, who are very opposite to the ideology that's going on, but have the evidence to prove otherwise, we are left, we've abandoned, and we have to do it ourselves. So that it takes a lot longer for these claims to get through. We don't have NGOs working for us. We have to do it all ourselves. So that's where we are at. Luckily, we have AI. AI is very, very good at writing up these claims and everything for me, but you've got to watch it because it does make some real errors, and it's just it's got to be watched, and you've got to be careful about using it because it does make a lot of errors, and but it's very good at writing it up for you and keeping it balanced and focused. I mean, when you've got all this evidence and it's quite emotional to you, then you can sort of end up going on tangent. So it's very useful for using AI in that sense. I think that AI will be censored because of the legal claims which it will be able to present to the courts. I think that that's going to happen because I've already seen in a couple of legal blogs in the UK that they're saying we think that there needs to be a censorship on AI because one of the errors was really to do with the claimant rather than the AI. The claimant didn't bring all the evidence that they needed. Anyway, we'll see how things go. I'm very tired today, and I'm going to just rest for the rest of the day. And then all weekend, I'm going to be writing up a lot of particulars of claims for a number of defendants. And my judicial review for the Home Office, and I do intend to put the NPCC either as a second defendant with the Home Office or a second defendant with the College of Policing. I've not decided yet, but I'm going to do that, or I might do both. I don't know. I've got to really, there's a lot of thinking about involved, and it's like a game of chess, and you've got to, this is one of the things that you learn on your law degree, you've got to be thinking about their moves in 2 or 3 moves ahead in the future. And I think they could be a bit arrogant with me. They have certainly appeared to be a bit arrogant with me as a litigant in person because they've revealed a lot of information which I have told them that I will be using against them in court. And they've said, right, we understand. So I think they're going to be a bit more careful with their words in the future, because they expressed a bit too much, maybe. I don't know. Yeah, anyway, I'm going to leave it there, and I hope you're all charged for winter and autumn and what have you, and getting your fires on if you're cold. It's quite warm, isn't it? It's not really been cold or anything really. It's been really warm, so I've been enjoying it. Anyway, enough chit chat. I'm going to get on and watch a movie. Okay, bye. Speak to you soon.